Gary Kaminsky, thanks for being here. We're going to kick it off right. Jeremy, welcome. We are. This is our first stream post July 4th, and Jeremy is an entire year older because of it.
I am. I turned 34 yesterday, so feeling my age a little bit, but happy to be here this morning.
How dare you say you're feeling your age at 34? That's BS. And contrary to popular opinion, Gary, we're not going to be talking about the Buffalo Bills today.
Oh, yeah. It's a little early.
I know, but hope springs eternal before the season starts, right? So we'll get to that as the season unfolds in Buffalo in the new stadium. But before we do any of that, Gary, you've been in the room at the DEA hearing on rescheduling. We're gonna pepper you with a bunch of questions because there's a lot.
Yeah.
Before we even get into what has been said or happening, paint the room for us, because in my mind, there's thousands of people in a crowded room, and it's super exciting. What do I have wrong in my assessment of what's happening in that room?
Well, the first thing is the thousands of people. It was as the industry has bemused. It is very limited as to who's in there. And picture, a judge, an ALJ, up on his pedestal there. To the left of, if you're staring at the judge, to the left of the judge is the witness chair. In front of the judge is the court reporter and his clerk. So when people were submitting documents, they'd give it to the clerk and he could easily get it to the witness. Front of that, a little further towards the back of the room, but still in with that chamber, were a rectangular table that housed 4 lawyers, which were all the opposition, and then set next to them another rectangular table that basically housed the 4 lawyers for Sam, because they had their own 4 lawyers plus 2 lawyers behind them.
Oh wow!
And then on a kind of perpendicular to the rectangular tables is the DEA table. And then you have, kind of the wooden bar, and then you've got the peanut gallery, which was 4 rows of basically that could fit 5 to 6 people a row on either side. And in the back row was reserved for press, which surprisingly there was very little of. I think I saw Cannabis Business Times and the New York Times are the 2 I spoke to. And then in the front, they had reserved for like DEA people. And that was it. And the courtroom opened at 8 a.m. and it was first come, first serve for the 25 seats for just the general public. And generally, if you got there at 7:30, you were probably going to get in, from what I could tell. And it went from 9 to 5. And then there was breaks like at 10:30, noon for lunch. And then I think there was a mid-afternoon break, but it pretty much ended at 5. So, whatever happened, the judge tried to do it. And, this is the judge was probably the nicest judge I've ever seen. He was very much a people pleaser, and he allowed a lot, because I would say that the opposition, and we'll get into it, because they really had nothing to talk about other than, their, as I say, the reefer madness dogma. They were testifying more than they were asking questions, in my opinion. And he was allowing it, even though he kept telling them to stop. And there were objections, things like that he ruled on. But I think he was pretty much trying to give everybody the opportunity to do whatever they needed to do.
So, Gary, you're representing Dr. Corey Birchman, who testified, in support of the rule. Talk about preparing for this hearing, right? Because, Dr. Birchman is in this sort of odd position of defending rescheduling in front of the DEA, which has been, the organization cracking down on cannabis, for its whole history. So talk a little about that about preparing for that testimony and what those conversations were like.
I guess I would portray it a little bit differently. Dr. Birchman was there to testify as an expert on pain management and as a fact witness generally on the cannabis industry, because they only were allowed 2 witnesses. And the witness was solely a scientist from the FDA who had a lot of experience with controlled substances and cannabis generally, but not with the industry. In fact, not really refused to and could not testify at all about the state programs. So Dr. Birchman was used in two parts. I wouldn't say as much as he was defending the rule as just he was there to prove CAMU, currently acceptable medical use. And the hearing is very limited. It's only about whether or not there is simply one CAMU. And if there is, it is not allowed to be on Schedule 1. And that's why it was a pretty straightforward exercise for the DEA. And their focus was, as was proven by the opening statement by Jamie Schwartz, who's the senior lawyer, is that we're not here about legalization. We're not here about regulation. We're here about CAMU. Is there a CAMU for this substance? And if there is, the schedule, it cannot be on Schedule 1. And Dr. Birchman, who has, been, and I've known Dr. Birchman for a very long time, and he was born for this exercise, I will just say.
Yeah.
Fair enough. And what were the, I want to sort of rewind a little bit where Marijuana Moment was aiming to get this hearing live streamed. We sort of were a party to that as well. Like, aside from us probably being bored watching it, like, was that addressed at all in the room, or have you ever heard of an ALJ hearing streamed, or was it over the long weekend and like nobody wanted to take care of it? Like, what do you think the rationale was behind that? Or is it totally out of left field that they would even consider it?
I'm not 100% sure I know why the ALJ was so strict on that. But I think that it could go back to the executive order requiring him to do it in an expeditious manner. And I think he tried to create a hearing that would be tight, expeditious, and allow him to do what he needed to do, get the evidence and facts that he needed. Why streaming would not be allowed, it really wouldn't interfere with that. That might go to more why he limited the witnesses. And I know the industry was very up in arms until, well, even after it was announced that there was going to be a witness, namely Dr. Birchman, on behalf of the industry. But prior to that, the articles we read in Marijuana Moment and others were very much critical, saying, oh, this is another kangaroo court. They're not going to give us our chance. But, on the one hand, after being involved in prep and also being at the hearing, I had the feeling that it may be a kangaroo court, but for once we're the kangaroo, and which is no, right? Because I think that it's and I don't think it's a political or any kind of skewed result. I think we all know that there is one CAMU for cannabis sativa L. I don't think that's a revelation to any of us. It might be a revelation to others. So from that perspective, if you're given that task, I think that the DEA's view was, we don't need to have a bunch of people on behalf of cannabis sativa L getting up there and complaining about all the people in jail and all the other side issues, which, while they may be important, have no bearing on this hearing. They felt comfortable that they could put forth their case, which was their burden of proof. And that's why it was so limited in terms of theirs. And then I think that the DEA decided, look, we'll give these 7 people who are already suing us an opportunity to be heard, to say what they have to say. And what ended up happening is it was almost like there were 2 different hearings going on. And I realized that very early on. Like I say, 2 ships passing in the night. You've got the DEA putting on a case that there's CAMU and that we followed a deliberative process at the FDA, HHS, DEA level. And then we have an expert who's going to testify about, who's done this for, over a decade and seen hundreds of patients. That's all we need to do. And the other side didn't even touch upon that, although they did they spent a lot of time in our spending time trying to discount the HHS process. And we could talk about that whole thing, but they couldn't really discount the expert other than to say, he's not allowed to testify because we didn't know he was going to testify, which was just incredible to see these high-priced lawyers who, frankly, several of them were very good, be at a loss when Dr. Birchman got up there and immediately started explaining the endocannabinoid system in a very poetic way for those of us in the industry. And when he said something to the effect of, you realize that there's billions of receptors and that endocannabinoid system is organic to the human body. And in essence, there's marijuana flowing through the human body. At that point, one of the guys stands up and objects on due process grounds, claiming that he was not prepared for this witness to testify about this. And he wants him stricken and taken off the stand. And he kept objecting, and the judge kept overruling. And then finally, the judge picks up the statement of case, which the DEA had filed, reads 2 sentences and says, this is actually exactly what we told you he was going to testify about.
Right.
Which told me at that point that they were in trouble with regard to him because I didn't know what they were going to ask him about.
Right.
Gary, talk a little bit about the mood in the room, right? Because on the one hand, you have, advocates and people from the industry like Birchman. On the other hand, you have smart approaches to marijuana, who is, you use the word dogmatic in their opposition to cannabis reform, right? Oftentimes when you read their press releases, et cetera, it's not very evidence-based. It's really sort of ideological. So talk a little bit about having both those sides in the room at the same time, what the feeling is like and how people are interacting.
Well, I think that everyone had a sense, and me personally for sure, that this was a historic hearing for a number of reasons. And maybe the number one is that as you mentioned, Jay, the DEA is on our side. Right. Considering, right. I have to tell you, going into their offices, being in an elevator with 5 DEA lawyers, I'm like, I never would have thought I'd do this.
It's not. That's generally not an ideal scenario.
No, yeah.
I thought about it afterward. I wish I would have gotten some swag. I could have used that little worn my
the jacket, right?
The jacket, yeah.
Yeah.
But no, I think everybody thought it was historic. And as you might guess, for instance, the SAM team, which is the Bill Barr firm, I don't know what the name of the firm is, they had an army of guys and an army of boxes of stuff. And, their lead lawyer, he had his underlings. And by the way, these underlings of his are like Harvard Law Review clerks. And he's like snapping his fingers at them when he needed something. And we were just laughing. Like, can you imagine being treated that way? And then
yes, we can. That's why we're not lawyers.
I know.
Right.
I resemble that, but I wasn't really working in a law firm for maybe that reason. But, but then you've got, while on the one hand, you've got a relative disparate group of people who are in opposition, but they clearly were cooperating among themselves and coordinating among themselves. And if you think about it, the hearing was really skewed to give them every opportunity to do whatever they wanted, because the DEA wasn't coordinating with anybody. They put rules on me on what I could say and do with regard to my witness in between hearings, because obviously I was sitting in there. I couldn't talk to him about what I saw. Right. So I really think that from that perspective, it was a very serious room, but there were plenty of comical moments. I mean, the lawyer, David Evans, for, I don't remember which one, I don't know what his deal is, but he just, couldn't ask a comprehensible question. So like when he cross-examined Dr. C, the first witness, Dr. Chip, He spent, you get an hour of cross. It took him 2 hours because there was an hour of objections. It's like the World Cup extra time. Seriously, if you object, they don't count it against your hour. So you never know how much
injury time.
It's exactly like the World Cup, ironically,
Yeah.
So, that was the mood. It was serious. Everybody, at first, I don't know if they thought because it was an ALJ, it was going to be less formal, but he had to explain, like this guy Evans, don't talk over the witness and definitely don't talk over me. And if you want to approach, you have to ask to approach. I mean, these are things that everybody knows, but it was what we thought it would be. And in fact, I know some people were not allowed in because I think if you get there after 8:30, whether there's spots or not, they won't let you in.
What is next? Because you said midway through, and in our sort of pitch to this, like we're sort of midway through. What do you expect next and going forward over the next couple of weeks?
Well, you know, the DEA rested on Wednesday afternoon early. And just I'll comment on that. Was I took the under on Tuesday night when I was speaking with the DEA on them using their 4.5 hours of cross, because it was clear to me that every time they asked my client a question, the record got worse for them, because they couldn't discount his expertise. I mean, you know, Harvard, Cornell, Dartmouth, whatever. And B, they don't know science like he does. So if they start asking him science, they're going to look bad. So they had very little that they could cross him on. So I knew they wouldn't take the whole thing. And there were a couple moments when they were crossing him that they made the mistake that you're not supposed to make, that you ask a question that you don't know the answer to. And the answer they got was very damaging. So even the Sam lawyer after that, he left an hour on the table. So it ended early. And then the next step was for the opposition parties to put on their opening statement. And then each of them get 2 hours to direct examine their witnesses. And then they'll be cross. What happened, and that really started yesterday. And although I should say on Friday, I guess there was, or I'm sorry, on Thursday, there might have been some opening. But in essence, what they did yesterday is they put this Harvard trained supposed expert up there to just go on and on about psychosis. You know, and they just been throughout the whole hearing, they constantly are talking about, you know, children smoking dope and killing themselves, and all these non-correlated studies, which Dr. Birchman made a big statement about the difference between causation and correlation. It's a big difference. And the way he described it was amazing, the example he gave. But point is, that's what we're seeing right now, and that's what we're going to see all week. And then after that, there will be briefing. And once that briefing is done, the ALJ will make a recommendation. And then that recommendation will go to the director or administrator of the DEA, who will then decide whether or not to reschedule marijuana in its whole to Schedule 3. And then whether it's before that point, if a federal court actually stays this, which I don't think they will, or after that point, these people will take this record and they will try to take the tidbits that they put on the record about psychosis, about the HHS 5-part test versus the 2-part test, and try to claim that the process that was used to reschedule medical marijuana was arbitrary and capricious. And that's how you challenge an administrative ruling.
I want to make, I mean, on that note, Gary, I just want to make, since we have a lot of viewers watching, something super clear, right? This hearing is not about the, you know, so-called dangers of cannabis use, of recreational cannabis use. It's really trying to establish, is there one specific medical use? And if there is that one medical use, it has to be removed from Schedule 1. That is right. Cool. And so what is the goal of Sam here, right, is to put all the stuff onto the record to build the case for an appeal in federal court. Like, how are they doing that? And you know, do you expect, I know you touched on this, but do you expect to see the final ruling tied up for a long time in litigation because of that?
Well, the way they were doing it is just putting a lot of dicta into the record, which was just every chance they got, whether it was the way they were, their questions were really arguments. They weren't questions in a lot of cases. And then when they would cross-examine, they would say things, isn't it true that XYZ study says that there's a direct correlation with the number of teens suicides to marijuana use? And things that are, and then, you know, luckily Dr. Birchman said, well, I read that study and I can count it. How would you like me to do that? And he would go through that and do that. The more, and then with him in particular, when they realized that they were going to have a hard time, they opened up the second day after his first, kind of mini day. And that's when I said it was going to be short. And he opens up by asking them, when was the last, are you high right now? And when was the last time you got high? And it just turns out that Dr. Birchman is not a cannabis user per se. Not that he's afraid of it, doesn't like it. It's just not his gig. But he does. It's funny because he's a mixologist, right? He loves to make drinks. So at times he's made THC drinks. And apparently he was on a podcast, Mary Jane or something like that, where the lawyer for Sam had watched it. And he said, isn't it true that on that podcast you said you enjoy a THC drink? And Dr. Birch was like, well, the word enjoy has got, many meanings. I've had one. I don't do it often, but, I could do that. Well, when was the last time? He's like, I don't know, about 6 to 12 months ago. So, I mean, that's not fun. And then the guy looked at him and goes, has there ever been, this was the best, has there ever been a FDA approved botanical plant? And he's like, Dr. Birchman goes, I'm really glad you asked that question, because just yesterday I read an article about VER1 and the FDA has advanced that in a breakthrough study, which frankly is historic for the industry because it's a full spectrum THC, CBD, CBG drug. And I'm very excited about what they're going to do. And that's when the guy kind of rested,
Right.
So, but then in answer to the second part of your question, I don't know. I walked away from that hearing thinking, okay, the DEA proved their case, but we don't control the federal courts. And all they got to do is find one judge who's who might want to do it. I don't think it will sustain on the appeal court or if it were to go to the Supreme Court, but I do believe there is a potential to kind of muck this up for a while.
Right.
I mean, money talks.
Right.
And, these are powerful lawyers who can always find ways to challenge things. Was the DEA, HHS, FDA process pristine? The problem there, and we might as well get into this now, is that the 5-part test that had historically been used just didn't work. It's a round peg in a square hole. They've never had a plant that has multiple cannabinoids in it, any one of which could be a drug, right? And are, by the way, CBD and THC are both approved drugs in different ways. But also, it was interesting because they were beating up on the FDA's scientists, asking him why he didn't take into account the state systems and the fact that they're not pharmacies and doctors aren't prescribing. And he's like, it's not my area, dude. I'm like, I approve drugs. I don't control the states. It's 50 of them. And I'm not involved in the dispensation of this drug. And by the way, I'm not an expert on FDA, but I would suspect that you'd be challenged to find another drug that the FDA has no jurisdiction over dispensation of. And that's kind of the shaky ground that this industry has been placed upon because of the really, frankly, uneducated and politicized and non-thoughtful regulatory mandates that we've been getting for over a decade.
Right.
I wonder, I mean, we pitched as sort of the most important hearing in 50 years as it relates to sort of cannabis use. One, do you agree with that sort of that qualifier for that? And do you think sort of a year or 10 we'll look back on this sort of 3 or 4 weeks as sort of a seminal turning point, or you think there'll be lawsuits, delays beyond that we think will maybe more important when it comes to rescheduling?
Well, I definitely agree that it's the most important hearing in the history of American cannabis. And I tried not to beat that into Dr. Birchman too much because, I just wanted him to do his thing, but I knew what it was. And I'm excited to see the transcript because I think it's going to be better than I remember. And, I was sitting next to a friend who represents some powerful people in the industry, and I felt like she almost wept when she heard him describe full spectrum on the record in a federal hearing advocated by the DEA. The other part that I really wanted the DEA to get him to testify about was the endocannabinoid system, because I've obviously heard him do that, and it was poetry. Because, I don't believe that the legislators understand the significance of the synergy between cannabis sativa L and the human body. And there is very strong science on that subject. So that record, I think, will live forever. I don't think that the court hearings are going to override that, because I don't think we've ever had anything like this where the government put on its record the advantages of marijuana.
In the last few minutes we have here, Gary, the hearing runs through the 15th. What happens next? Who else is going to testify, and what can we expect over the next couple of days?
Well, I mean, all 7 of the opposition parties have the opportunity. Yesterday was this Dr. Madras, who was the first SAM witness. Today is Lulu. I think her name is Lulu, but she is, I believe it's a she. She is actually a DEA scientist that is not in favor of marijuana, and they're putting her on. And they're trying, and that guy, the SAM guy who's doing those videos on social media is like, oh, they refused to let him testify or her testify. Well, that's not the case. They chose not to use her as a witness because it didn't support what they're trying to achieve, obviously. So that person's going to testify. And then you're going to get others. But all of them are a disparate series of reefer madness dogma that says this plant is dangerous. And if we unleash it on America, we're in trouble. The problem is it's unleashed. And that's what the FDA scientist said, the first DEA witness. He said, we've never had a drug that we're trying to figure out whether it should be in Schedule 1 that is prevalently dispensed in 40 states where they've said it, there's medical use for it. So, that's kind of this crazy situation. So you're going to continue to hear all these things. But I think the arguments they're making are not going to be a surprise to anybody. I think they've been making these arguments, whether it's psychosis, whether it's trying to claim that it's, if one person says that marijuana isn't good for PTSD, which is completely false, they're going to say that this is going to cause veterans to commit suicide because it accelerates their psychosis. But they can't counter attack Dr. Birchman's clear statement that in his practice, he transitioned opiate addicts off of the dangerous drug that could potentially kill them to a drug that could not kill them, and that actually alleviates their pain and has other inflammatory benefits. He gave the example of the receptors, right? And opioids hit receptors, I think they're called mu, in your brainstem, right? And the receptors are for breathing and your heart. So he's like, when you take too many of these, which you have to, because as you take more, you need more, and they don't work anymore, but now you're an addict, so you're taking them. Well, you run the risk of not breathing or having a heart attack. And he called that a dumpster fire, and he called withdrawal from that a dumpster fire. On the other hand, he said, we got billions of CB1 receptors, and if you take too much, you're not going to have those types of problems. You may feel uncomfortable for 12 hours, but you're not going to die, and you're going to be fine, and you're going to get the relief, and you're not going to have withdrawal. And he likened that to like a slow burning ember in a fire. And when he said those things, the lawyer, the cross-examining lawyer goes, well, isn't it true that a dumpster is contained? He's like, look, I'm not going to try to explain to you what a dumpster fire is, dude. It's like, it's not contained. That's the whole point. Yeah, it's in a dumpster, but that's what they call it. I mean, that's kind of giving you an example of the straws that they were reaching for to try to discount what is pretty much objective fact.
This has been awesome.
Awesome.
I mean, I think
awesome.
I think even though we've had reporting from it, we've read sort of things you've written and said, I do think being able to pepper you with questions sort of to get the full context and the color is invaluable to sort of our understanding what's happening in the room and to actually paint the picture of the room, because everything you said, even what my view is like fairly uncomfortable moments between ALJ judge, the witness says, and the lawyers and the DEA, like it's actually in a living room. Like it's you didn't talk. There's not 50 people. It doesn't sound like a sort of in the room. So like it actually is happening as people can sort of hear each other breathe, which is I think interesting to sort of think about from the sort of the context perspective, what's happening in the room. It's been it's enlightening, really.
Yeah, and I'll say this. You know, you probably saw the social media post by Sam last week when one question, and frankly, it was 40 minutes of objections before they got, and I give the lawyer for Sam credit because he kept fighting through it, and he finally got the doctor to answer yes to the question of would marijuana have failed the 5-factor test? And they made it sound like, oh my God, that's like enlightening. Well, it's because the 5-factor test was not built for a substance like this. So it couldn't be used. There are factors in there that are not relevant to marijuana. So the OLC, the Office of Legal Counsel, had to mandate that they use the 2-part test, which was more appropriate for marijuana. That doesn't mean that it was skewed. It means that they're doing their job. I mean, the DEA, HHS, and FDA spent 10 months looking at hundreds of studies, hundreds of documents, talking and doing analyses and coming up with a conclusion. It wasn't like somebody moved the dial.
Right.
And that's their only hook, is that study, the 252-page HHS report, is arbitrary and capricious, and therefore the medical should be set aside.
It's always remarkable that the vast majority of 9th graders in America and Canada understand that correlation isn't causation, yet the CEO of Smart Approaches to Marijuana continues to struggle. It's one thing to get that all on the record and to see it happen.
Well,
so
as if we have the time, I'll tell you what Dr. Berkman said. So on redirect, the DEA asked him a couple questions, and one of which was, please tell us the difference, because this has come up a lot today, Dr. Berkman, of causation and correlation. And he says, well, bear with me on this one because you're going to think it's ridiculous, but this is how I explain it. If I had a whiteboard, I'd put it on it. Think of a graph with the axis on the bottom is time, and the axis on the left is the amount of cheese that Americans eat. And over time, it's going like this, okay? Just trust me that that's the way it is. Now let's do another one. The one on the bottom is time, and the one on the left is how many people suffocate in their bed from their sheets over time. They're 93% correlated to be the exact same thing. But I don't think you would say that if people eat more cheese, they're going to suffocate in their bed. That's right. So, I mean, to me, that said it all. And the other remarkable thing that happened was when she was done with her redirect, the judge said, can I ask a couple questions? And he said, Dr. Berkman, do you know the definition of marijuana in the CSA? And he reads it to him. And of course, Dr. Berkman knows that definition. So he goes, when you're talking about medical marijuana, which, by the way, he wasn't talking about, he was talking about marijuana. He said, how do you define medical marijuana? He's like, I don't define medical marijuana. I don't believe there is medical marijuana. There's no recreational marijuana. And I think at some point he even said the same about hemp. There is one plant, it's called Cannabis sativa L. And when I talk about the camus of that plant, I'm talking about that. And so the judge goes, so you're saying that your definition is within the definition of the CSA? He goes, yes. And I know that those of us in the industry, I'm not per se an aggressive one planter just because of the complexities. Plus, I work very closely in the hemp derived beverage business. So I get the value of having that opportunity. But it is true. It is the same plant.
Will you come back as time goes on and we get more from this?
I'd love to. I appreciate that. No, I enjoy this. I enjoy talking about it. I've been, I for the first, I guess, 30 some odd years of my life, I was a securities lawyer, busting people for insider trading, and a hedge fund trading lawyer. And for the last decade, I had to find a better compliance geek exercise, and there's no better than this business. So I've worked at a number of MSOs and hemp, so I really enjoy it. So I appreciate it.
Well, we appreciate having you.
Yeah, thank you.
This was great.
This is awesome.
This is like Jeremy and I are cannabis, certainly regulatory nerds. And this is like a perfect birthday present for Jeremy to be able to talk about it. So.
That's right. That's right.
I don't know, but if you know, you're 34, you say, well, my 34-year-old is getting married this weekend. I'm flying out to LA for that. So.
Congratulations. Yeah,
well,
amazing.
Congratulations.
That was me last year. So yeah.
Yeah. Well, good. Well, congratulations. Safe flights to you. Safe travel. And we will catch you as this winds up over the next couple of weeks, and maybe we'll have you back to sort of digest what we know.
That would be great. Thanks for having me. I appreciate it.
Thanks, Gary Kaminsky. Thanks so much for being here. Jeremy, nice to see you. Happy birthday again. And we'll be back again tomorrow, actually, with Brett Puffenberger talking about Virginia regulations and what to expect in the Commonwealth of Virginia over the next year. Thanks, everybody. We'll see you tomorrow.
Bye.
Bye, y'all.